Thank you so much for joining us. My name is Abe Mashni. I'm going to be your host today, and we are at the Baldani Law Group studio here in Lexington, Kentucky. First off, just thank you for tuning in. I hope this is going to be interesting for you. So this is episode 2, and the first episode of our Suppression Series talked about just general introductory stuff. What is suppression hearing? What can be suppressed as far as evidence-wise? And some strategical considerations to consider. And so now we are in episode 2, and in this episode we're going to be talking about Miranda. And so let's go. Why does this matter? And so whenever you talk about Miranda, it's going to be talking about your Miranda Rights, and it's going to be talking about confessions. And so confessions can lead to charges filed against you, enhanced charges, further evidence to support a prosecution's case. It may give the prosecutor the playbook for what defenses you may raise in the future. And it could give, if you give information that law enforcement didn't already have, it could give them probable cause to search another place. And so with Miranda issues, we're talking about statements that you as the defendant make. We're not talking about statements that witnesses make. We're talking about your individual statements that could be used against you. And so there are 2 constitutional violations that could stem from Miranda issues, and those are the 5th Amendment and the 6th Amendment. And so the 5th Amendment, no person shall be held to answer for any capital or otherwise infamous crime unless on a presentment of indictment or grand jury, except for cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject to the same offense to be twice put in jeopardy of life and limb. And here's where this is the right to not self-incriminate yourself. And so, nor shall be compelled in any criminal case to be a witness against himself. And so that's what we call, some may call it the right to remain silent, right to not incriminate yourself. But that's the biggest thing. In a criminal case, nobody can force you to testify against yourself or give a statement that is going to hurt you in the future for a criminal prosecution. And so the 6th Amendment applies as well. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury by the state and district wherein the crime have been committed, which district law shall have previously ascertained by law, and be informed of the nature and cause of the accusation to be confronted. Here's where it goes. The last sentence. I've bolded it, I've underlined it, and to have the assistance of counsel for his defense. And so the law, the courts throughout the years have deemed there are certain stages in which a lawyer can and should be present. And that's what we're talking about today. So pre-Miranda, in the early 1900s, physical abuse was acceptable, if not legal, method of getting a confession. And so you've heard of the saying, the 3rd degree. And so law enforcement officers, detectives, they were depriving suspects of water, of food. Whenever you see the dark room with the bright, shiny light facing on the suspect and then asking them questions and yelling at them. That's what we're talking about. Physical discomfort, long isolations, even physical abuse, beating with rubber hoses so as to not leave a permanent mark, but to intimidate. And some may say that this is forms of torture nowadays. But these were all legal, and these were all forms of justifying a confession, as long as the suspect signed a form at the very end saying that that confession was voluntary. And so as long as they got him to sign it and they broke him down and wore him down, then it was all good. Then came Brown versus Mississippi, and in that case, it's a United States Supreme Court case in 1937. In that instance, the Supreme Court threw out a voluntary confession that was obtained after police officers repeatedly strung a suspect up a tree and whipped him. And so that bright line rule in the Brown v. Mississippi case is confessions cannot be obtained by force and then subsequently used at trial. So then we get to the seminal case, Miranda v. Arizona, and this is a 1966 United States Supreme Court case, and so Miranda, it's actually Mr. Miranda. His first name was Ernesto, and he was alleged to have done some pretty awful things. He was arrested at his house. He confessed after about a 2-hour interrogation to rape and kidnapping. And at trial, there was an oral and written confessions that were presented to the jury. He was subsequently found guilty, and he faced about 20 to 30 years on each count. And so he appealed, and his case ended up at the United States Supreme Court. And the issues that he raised was that he should have been afforded the opportunity to have counsel present with him while he was interrogated, or at least the knowledge that he could have counsel present, and that he had the right to not talk to the police officers, and had the right to not, and to remain silent. And so what the Supreme Court held was the prosecution may not use statements, whether exculpatory or inculpatory, stemming from, and this is a big buzzword that we're going to talk about in a minute, custodial interrogation of the defendant unless it demonstrates the use of procedural safeguards effective to secure the privilege against self-incrimination. By custodial interrogation, we mean questioning initiated by law enforcement officers. That's a big one as well. It's got to be initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. And so we're going to break it down. So when does this right apply? When do you have to be informed of your Miranda rights? And it occurs in two situations, and they both have to be present for these to kick in. And so you must be in custody. There's been a lot of definitions throughout the years, and courts have really struggled with what does in custody mean. And so there's some obvious examples of you're in jail. If you're in jail and they want to come talk to you, well, then that's a very good example of in custody. What about if you've been handcuffed and put in the back of a police car? I think there's a very good case that is in custody. And so, but there's a lot of times in which there's situations where people are not free to leave and they have been detained. And so those are the close calls in which the courts have to look at as far as whether or not they're in custody. And the standard is otherwise deprived of his freedom of action in any significant way. And so if an officer calls you on the phone, well, then you're not in custody at that point. And then also, number two is you must be interrogated. And so if I volunteer the information, or if unprompted I just start confessing my all the crimes, then that doesn't count, because you were not interrogated. You voluntarily gave that information to the law enforcement officer. And so what I'd like to do is, here's a general order from the Lexington Police Department. I believe it's still current. The effective date was 2018. I haven't found anything otherwise to show that there's a new or updated version of this general order. But this talks about interviews, interrogations, and confessions, and it gives the blueprint of what officers here in Lexington are trained on and taught in related to these situations. And so first, let's talk about when does it not apply. And so we talked a little bit about it, but here's coming straight from the general order from the Lexington Police Department. The following represents examples of situations that are not custodial and do not require the issuance of Miranda warnings. And so one is a Terry stop. And so a Terry stop is a general stop between an officer and a suspect, in which they don't necessarily have to have probable cause for the Terry stop. A lot of times there's a pat down for officer safety. It's a general conversation in which somebody may be free to leave after a short amount of time. And so that is a Terry stop. Questioning during a routine traffic stop for a minor violation, including DUI stops. And this is really big, and what you see here is an officer will pull somebody over, have a conversation outside of the vehicle or while the person's still in the vehicle, and ask them questions that will directly pertain to a DUI investigation. Have you been drinking tonight? Where are you coming from? Those type of things. That's not covered by Miranda. And so you could ask for an attorney during that point, but it's not going to kick in, and there's not going to be a suppression issue during those routine traffic stop situations. And so during a routine questioning at the scene of an incident or crime, when questions are not intended to elicit incriminating responses. Now come on, routine questions where they're not intended to elicit incriminating responses. And so this is tough, because although they say that they can do this, I think that in certain situations you can have violations, especially if it turns into incriminating information really quick. And so that's one thing that they say. That's their opinion, that is not custodial. But I think that's a little bit more of a close call. During voluntary appearances at the police headquarters. And this is huge, because when a police officer calls you and say, hey, do you mind coming in and talking to me for a little bit? Miranda technically doesn't apply, because you are voluntarily coming into the police headquarters to give a statement, and what they're going to say is that you're not in custody. You weren't arrested, you weren't in handcuffs, you weren't in jail, you could leave at any point, it was voluntary. And so that's it's never a good idea. And then finally, when information or statements are made spontaneously, voluntarily, and without prompted. So this is whenever you just blurt out what you have to say, and they're not specifically asking. In those situations, Miranda does not apply. You don't have a suppression issue, and the jury will be able to hear what you have to say at the end of the day. And so, what are they required to say? And I feel like the saying gets said so much. You see it in movies, you see it in TV shows, you see it, it's almost everybody can repeat it, but they're not listening. You're not taking in what they're saying, and or maybe you're minimizing and just not just doesn't think, I know those rights, but maybe not really understanding the importance of those rights. And so what this general order says is the officer has to advise, and sometimes, a lot of times, it's on a card where they just read it real quick and just try to get it in and out and over with, and try to accomplish their task. And so you have the right to remain silent. Anything you can and will be used against you in court. You have the right to an attorney before making any statement, and may have your attorney with you during questioning. If you cannot afford an attorney or desire one, the court will appoint you one. You may stop questioning at any time by refusing to answer any further, or requesting to consult your attorney. And then they follow it up with, do you understand each of these rights as I have explained it to you? And with these rights in mind, do you still wish to talk to me? And then they try to say it really, really quickly, get it over with, and then get the consent, and then move on, and boom, start asking them questions that undoubtedly is going to incriminate the person. And so that's what is required. And if they don't say this, if they don't give you your rights, and you are in custody and interrogated, then that is ripe. Those are grounds to suppress those statements to where a jury would never hear those statements that could, in a lot of cases, significantly impact what the ultimate result of the case is going to be. And so here are the situations so once you have invoked your right to silence, once you've been read, let's say you are in custody, you are being interrogated, and you tell the officer, I don't want to talk to you. I want to invoke my Fifth Amendment right to not self-incriminate myself, and I want to remain silent. And so here's what the general order from the Lexington police say in those situations. Here's what the officers should do and what are trained to do when a suspect invokes their right to remain silent. When a suspect invokes the right to remain silent, all interrogation shall terminate immediately. And so if they want to ask you questions more, or if they just want to talk to you, that is against their rules. And so that would be a violation of Miranda. Although a suspect's invocation of the right to remain silent requires immediate suspension of questioning, and this is big, it does not preclude the resumption of questioning at a later time. If questioning is resumed after a reasonable amount of time, and what is a reasonable amount of time, that's going to be ultimately up for a judge to decide. The Miranda warnings must be again administered, and a new waiver must be ordered. And so this is big because we're going to get to what the difference is between remaining silent and invoking your right to the Fifth Amendment right to not self-incriminate yourself versus invoking right to counsel, which would be your Sixth Amendment right. And so the biggest difference is number two. The rules are you have to stop. You have to stop terminate the interrogation, and they have to quit interrogating you at that point. But what comes into play is the more protections that you get if you invoke your right to counsel. And so when a suspect invokes the right to counsel, all interrogation shall cease immediately. The suspect may not again be interrogated by any officer from this or other agencies about a crime for which they are charged or about any other crimes unless, and these are the three big exceptions. The suspect's attorney is present during the questioning, and I guarantee you if an attorney is present, they're probably not going to let them talk. And then two, the suspect initiates new contact with the police. And I literally just had this happen last week in a federal case. My client rightfully said, I want to talk to my lawyer. They tried to talk to him more, and we held a suppression hearing, and the government tried to say that, well, he reinitiated contact. He tried to get their attention, and he tried to, but thankfully we ended up winning that one, and that significantly changed the outcome of his case. And so it is really important that's one thing that the government will use a lot is the reinitiation of contact. And if you do that and they're successful at proving that you reinitiated contact after asking for a lawyer, well, then those statements get in, and they can use those incriminating statements. And then the last is there's a 14-day break between when you first ask for an attorney. They have to wait 14 days, re-Mirandize you again. And if you waive your right and you want to talk to them at that point, then it's okay. And so the privilege against self-incrimination serves as a protection to the innocent as well as the guilty and should be given a liberal construction. And so this is from a Supreme Court case back in 1956. And so whenever people tell me, well, I don't have anything to hide, or I'm innocent, so why shouldn't I talk to police? I don't have anything to hide. These rights are meant for a reason, and they're for innocent people, they're for guilty people, and you really, really should consider first talking to an attorney before you make any of those decisions, and secondly, just exerting those rights and asserting them. Just say, I want to remain silent. Another one is a Justice Robert Jackson. He was a former Solicitor General. He was former Attorney General. Ultimately made his way into the United States Supreme Court Justice in a dissent that he wrote in 1949. So this guy is a prosecutor through and through, and then made it to the highest court in the land. And so what he wrote in one of his dissents in the Watts v. Indiana case is, any lawyer worth his salt will tell the suspect in no uncertain terms to make no statement to the police under any circumstances. No truer words could be said. I mean, we see it all the time, is whenever we're talking to clients, well, what did you talk to the police? What did you say? And undoubtedly, it'll be something that they will use against them, whether it's just something inconspicuous or something maybe the officer doesn't, maybe it's a true statement, but the officer doesn't believe it, and the prosecutor will try to use it against you. And so these are really, really important rights, and so just make sure of that. So in conclusion, we've talked about what it is, what rights are in play for Miranda issues. We talked about what officers need to say in order to properly give you the Miranda rights. We talked about the two situations that it applies in. We talked about the differences on what police should do versus asking for an attorney versus asking to remain silent. And so to sum it all up, to bring it home, we're going to say, so even if you aren't sure in a situation where Miranda applies, and so maybe you're not sure if you're in custody, or if you're not sure the officer is interrogating you and maybe just having friendly conversation, always invoke your right to counsel. Always. Because just do it, and don't reinitiate, because if the officer is truly having a friendly conversation with you and you invoke your right to counsel, it does not allow them to go forward. It doesn't allow them to talk about anything else. It doesn't allow them to ask anything incriminating against you. And they can't go forward. And if they do, it's a violation and it gets suppressed, even if they wanted to use the information against you. So, number 2, never reinitiate contact. That's something that they'll do. They'll say, well, he wanted to talk to me, or he gave a wink, or he gave a head nod. Don't give them that. Just do not. And even if they think that you want to reinitiate contact, you make sure to tell them, I want my attorney present for any questioning whatsoever. There's always some instances where law enforcement makes sense, where talking to law enforcement makes sense. But those situations are always going to involve an attorney. For instance, in a situation where a detective wants information about a certain crime, they try to reach out to a client or a suspect, and he didn't want to talk to him. Suspect retains me, he becomes a client. And so I'm able to do the legwork. I'm able to talk to the defendant or to the detective. I'm able to talk to the prosecutor. And we're able to work out a deal in which is significantly better than what would have happened if he would have just walked in and gave his side of the story and gave out and told him what he knew about the case. Because I'm able to talk, not incriminate my client, and arrange for a deal in writing to handle the entire case. And so now, because we still have the leverage, so it's all about negotiations. And if you go in and you give a statement, then you lose all of your leverage. They have what you want. They have what they want from you, and you're done at that point. But if you go in with an attorney that's prearranged a deal that's going to work out a situation for you for favorably, then you go in, then it's already done. You have nothing to worry about. You know what you're going to get into, and your attorney has advised you and was there with you to make sure you didn't make matters worse. Miranda rights only deal with statements and confessions to law enforcement. And so, for example, we get this all the time in a drug case or an assault case or in any type of, really any case, a client undoubtedly will call me and say, they never told me my Miranda rights, or they never told me my rights. I can get this case dismissed, right? It doesn't work that way. And so, for example, if an officer finds 5 kilos of cocaine in your car, places you under arrest, asks you some questions, but doesn't read your Miranda rights, that doesn't mean it's a get-out-of-jail-free card where the drugs go away. No, it only means that any statements that you made while being interrogated would not be admissible at court. And so you're still stuck with the drugs that you now have to account for. And so I hope you enjoyed it. Thank you so much for joining us. And we're going to have a lot of these coming in the future in our Suppression Series and Baldani TV podcast. And if you liked it, please like this on Facebook. Please share it with other people. If you're watching this on YouTube, please subscribe to our channel and like it as well. And as always, if you have any questions about any of this, please feel free to give us a call at 859-259-0727. Have a good day.